Each recorded action speaks volumes. Every close observation uncovers facts. Protecting your civil rights, revealing definitive justice.
Lines Immigration and Customs Enforcement, conducting routine compliance verification.
The State Superior Court Judge en route to preside over morning session.
And good.
The Georgia interstate near Macon was choked with traffic when it happened. Tuesday morning, 8:37 a.m. The kind of November chill that demanded heated seats and steaming coffee, frost still clinging to highway overpasses like forgotten lace. Deborah Hatchett had merged into the commuter crawl heading toward the courthouse. Still in simple office attire, charcoal blazer, pressed slacks, her judge's robe folded carefully on the passenger seat beside her briefcase. Her mental docket reviewing the morning's cases, the motions she'd need to address before lunch. Just another Tuesday commute, except the unmarked ICE van weaving aggressively through traffic behind her hadn't been there 3 exits ago. Body cameras already activated on the agents inside, recording what would become the most expensive traffic stop in Georgia history. If you're ready to see institutional racism taken down, like this video and drop a comment telling me where you're watching from. And if this is your first time here, hit that subscribe button right now, because you won't want to miss tomorrow's story of cops messing with the wrong people and finding out. Let me know in the comments if you enjoyed this story. Agent Randall Kemp led the maneuver. His partners, Agents Vickers and Doyle, flanked wide as the van's sirens chirped twice, sharp and decisive, forcing Deborah toward the shoulder. Traffic surged around them in honking chaos. Kemp moved with tactical precision, hand already gesturing toward her door before his boots hit the pavement. Deborah watched it unfold through her rearview mirror, the aggressive positioning, the body camera's red recording lights, the rehearsed authority of men who'd already decided her guilt. 23 years on the bench, 2 decades of reading hostile witnesses and calculating courtroom threats had trained her to catalog danger in seconds. Federal agents, immigration and customs enforcement patches stark against tactical vests, approaching her sedan like she was already convicted of something. She knew where this was headed before Kemp reached her window. Behind her, a yellow school bus crept forward in the gridlock, small faces pressing against fogged windows, children watching. Their morning route to elementary school interrupted by flashing lights and the spectacle of authority surrounding a lone black woman on the highway shoulder. Deborah kept her hands visible on the steering wheel. Slow breathing, no sudden movements. 23 years of facing down prosecutors and hostile cross-examinations had also taught her that reflexive reactions around armed officers ended in tragedy. Kemp's voice carried through her closed window, flat, administrative, stripped of humanity, immigration and customs enforcement, conducting routine compliance verification, need you to exit the vehicle and provide documentation of legal status. The words were procedure without thought, authority without accountability. The demand hung in the cold air between them. Deborah lowered her window 3 inches, enough to speak, not enough to surrender control. Her judicial badge was already in her hand, state seal catching the weak November sunlight. Deborah Hatchett, Georgia State Superior Court, en route to preside over morning session, my credentials and identification. She extended the badge through the gap. Kemp barely glanced at it. His eyes moved past her face to the interior of the car, scanning, assessing, dismissing. Vickers stepped closer to the passenger side, peering through the window at her folded robe, her briefcase, the mundane details of a professional commute. Going to need immigration documentation, passport, naturalization papers, visa, standard compliance check. The courthouse is expecting me in 40 minutes. You can verify my identity through the state judicial database. My court ID number is... Kemp's hand moved to his belt, not to his weapon, but to his handcuffs. The gesture was casual, practiced, inevitable. Doyle circled behind her vehicle, blocking any retreat. The traffic around them had slowed to a voyeuristic crawl, phones emerging from windows, recording. "Ma'am, exit the vehicle now." The school bus had stopped completely. 32 children, ages 6 through 11, watched through street glass as Deborah complied. She stepped onto the shoulder, gravel crunching under her work shoes, her hands raised to shoulder height without being asked. The cold bit through her blazer. Behind the bus windows, small faces registered confusion, then fear. A little girl in the 3rd row started crying, her sobs visible even if not audible. Deborah kept her voice steady, procedural, anchored in the constitutional law she'd spent 2 decades interpreting. I'm invoking my Fourth Amendment rights. This stop lacks reasonable suspicion. I've identified myself as a state official with verifiable credentials. I'm requesting immediate supervisor contact and documentation of your basis for detention. Kemp moved behind her. The handcuffs were cold, tighter than necessary, metal biting into her wrists with deliberate pressure. The click of the lock echoed across the highway shoulder. To see ha, Askenpower with Weiler. To see ha percent B with Weiler haps is in effect of with where a was in the feeler. Kemp lock if according in the family his. Around them, traffic had become a slow-motion audience. Phones captured every angle. The children on the bus were crying now, multiple small voices joining the first girl's distress. Verification takes time. You'll wait in the vehicle while we confirm your story. They walked her to the van. Vickers opened the rear door, a cage-like compartment with metal benches and no windows. Deborah stepped up, her bound hands making the movement awkward. Behind her, her sedan sat unlocked on the shoulder, hazard lights blinking uselessly. Her robe was visible through the windshield, black fabric folded with precision, a symbol of authority now irrelevant. The van door closed. The sound was final. Inside, the space smelled of industrial cleaner and old coffee. A metal bench ran along one wall. Deborah sat, her mind already shifting into litigation mode, badge numbers memorized. Kemp's nameplate, R. Kemp, badge 4729. Vickers, J. Vickers, badge 5183. Doyle visible through the wire partition, T. Doyle, badge 4991. Time of stop, 8:41 a.m. Location, Interstate 75, mile marker 147. Witnesses, minimum 30 civilian vehicles, one school bus, estimated 30-plus children. The van began moving, not far, just to a holding area 200 yards up the shoulder, but the displacement was strategic, distance from the immediate scene, reduction of visibility, standard detention protocol. Through the partition, Kemp's voice carried back, casual, almost cheerful. That's 3 this week. Quota's looking good. Vickers laughed. You see the breakdown Jenkins sent? $2,200 per head if they end up at the facility. Contractors love high-traffic corridors. Deborah's hands, still cuffed behind her, found the edge of her smartwatch. Her fingers moved with deliberate care, pressing the side button twice, then holding. The watch vibrated once against her wrist, recording activated. Kemp continued, unaware. Targeting's easy when you know the patterns. Professional types think their suits protect them. Black woman, nice car, morning commute. Probably got papers, but the check still counts toward metrics. Deborah sat motionless, every word cataloged, every admission documented. The hour crawled past. Her court session began without her 9:15 a.m. Judge Hatchett's absence noted in official record. The case she was to preside over, a complex civil rights matter involving housing discrimination, was postponed. Attorneys waited. Plaintiffs waited. The court clerk made apologetic calls. At 9:41, Kemp's phone finally rang. The conversation was brief, his tone shifting from confident to uncertain to defensive. When he opened the van door, his face carried no apology. You're free to go. Verification came through. No explanation. No acknowledgement of the hour stolen. The humiliation broadcast across social media by now, the constitutional violations recorded from a dozen angles. Deborah stepped out onto the shoulder. Her sedan sat where they'd left it, unlocked, vulnerable. Traffic had returned to normal flow. The school bus was long gone, those children now sitting in classrooms, traumatized by what they'd witnessed. She drove the remaining distance to the courthouse in silence. Her hands shook slightly on the wheel, not fear, but fury converted into methodical planning. She arrived at 10:07 a.m., walking through courthouse halls where colleagues and staff had already seen the videos. Their faces showed pity, outrage, helplessness. In her chambers, Deborah closed the door. She pulled up the bystander footage already circulating online, 17 different angles, the children's faces visible in several shots. Her own composure captured in high definition as she recited constitutional amendments while being handcuffed on a public highway. She opened a new document on her computer, started typing, badge numbers, timeline. Verbatim quotes from the overheard conversation, backed by the smartwatch recording she'd already downloaded and secured. Names of the children's families, which she'd obtained through the school district. Witness contact information from the license plates visible in the videos. Then she made a call. The attorney who answered was one she'd known for 15 years, a civil rights specialist who'd argued cases before her bench with precision and moral clarity. The conversation was brief. When it ended, Deborah returned to her documentation. The case she was building had nothing to do with her scheduled court docket and everything to do with a different kind of justice. The kind measured in precedent, accountability, and institutional reform. Outside her window, the city moved through its ordinary Tuesday afternoon, but the roadside reckoning had already set something irreversible into motion. The attorney's office occupied the fourth floor of a renovated Atlanta building where exposed brick met modern glass, history preserved inside progress. Deborah sat across from Julian Cross, her civil rights attorney, in a conference room lined with case files and framed verdicts. Between them, a laptop displayed the smartwatch recording, her voice clear and steady reciting Fourth Amendment protections while Kemp's casual admission about quotas and profits played in damning stereo. Julian rewound it for the third time. $2,200 per head. Contractors love high-traffic corridors. The words carried weight beyond their casual delivery. They suggested system, not aberration, policy, not individual misconduct. Deborah had brought everything. The recording. 17 bystander videos compiled into a synchronized timeline. Deborah had brought everything bystander videos. Her own meticulous documentation, badge numbers, timestamps, the exact wording of Kemp's demands, medical photographs of the bruising on her wrists where the handcuffs had bitten too tight, the postponed court records showing the professional cost of her detention. Julian outlined the charges with clinical precision. Unlawful detention without reasonable suspicion, racial profiling in violation of equal protection, intentional infliction of emotional distress, violation of Fourth Amendment rights under color of federal authority. Each count mapped to specific evidence, to precedent, to constitutional text that Deborah knew as intimately as her own heartbeat. But the smartwatch recording opened a darker avenue. If the bounty system was real, if private contractors were incentivizing detention in minority-heavy corridors, then this transcended individual agents. This was institutional corruption. Julian filed the subpoenas himself. Federal procurement records, ICE detention contracts with private facilities, internal communications regarding performance metrics and bonus structures, email correspondence between field supervisors and contractor representatives. The requests were precise, legally airtight, impossible to dismiss. The documents arrived in waves over 6 weeks. Each batch deepened the conspiracy. Contracts between ICE and 3 private detention companies showing per detainee payments escalating in quarters with higher minority populations. Internal memos discussing optimal enforcement zones that mapped precisely to Black and Latino neighborhoods along major commuter routes. Spreadsheets tracking individual agent productivity with detention numbers color-coded by demographic profiles. Then came the deposition transcripts, routine procedural questioning of Agent Kemp about his employment history, his training, his prior interactions with the judicial system. Deborah was reading through the standard responses when a case number caught her eye. A domestic violence proceeding from 3 years prior. Kemp had testified as a character witness for the defendant, a fellow federal employee. She cross-referenced it with her own case archives. The file opened like a trapdoor. She'd presided over that case, had found Kemp's testimony evasive, contradictory, ultimately unreliable, had issued a ruling that explicitly questioned his credibility on the record. The defendant had been convicted partially due to Deborah's evidentiary rulings that excluded Kemp's statements as untrustworthy. 3 years later, Kemp had stopped her on a highway and detained her for an hour. Julian absorbed this information with the careful stillness of someone calculating legal strategy, retaliation by a federal agent against a sitting judge. It elevated the case from civil rights violation to targeted vendetta, adding layers of mens rea that made the constitutional arguments even stronger. The government's response came 10 days later. An initial settlement offer, $50,000, confidentiality clause mandatory, non-disclosure agreement permanent, no admission of wrongdoing. The offer was insulting in its transparency, hush money, structured to protect the system while silencing the victim. Deborah rejected it in writing within 4 hours. The offers escalated. $75,000. $120,000, $200,000. Each iteration included stricter confidentiality terms, longer non-disclosure periods, more comprehensive liability waivers. By the fourth offer, $300,000, the terms prohibited Deborah from ever discussing the case publicly, from cooperating with media inquiries, from providing testimony in related matters. She rejected each one. Julian filed amendments to the lawsuit, broadening the scope to include the private contractors as defendants. If they were profiting from racial profiling, they'd answer for it in court. The eighth offer reached $800,000. The confidentiality clause now extended to all parties, including potential witnesses, bystanders, even the traumatized school bus children's families. The government was trying to buy silence wholesale. Deborah's rejection was 3 sentences long. No settlement without public accountability, no resolution without institutional reform. Trial was the only acceptable outcome. She returned to this decision during late nights in her chambers, reviewing discovery documents by lamplight. Emails between contractor executives discussing revenue optimization through enhanced corridor targeting, bonus structures rewarding agents for detention numbers that exceeded baseline projections, statistical analyses showing enforcement patterns concentrated in majority black census tracts during peak professional commute hours. Do you believe federal agents should face personal consequences for retaliatory actions? The question played in her mind as she drafted legal arguments, as she corresponded with Julian about trial strategy. Drop yes or no in the comments below. Explain why it could safeguard professionals like judges from such vendettas. Share this video to highlight the need for transparency and enforcement. The flashbacks came unpredictably. Mid-hearing, while listening to an attorney's oral arguments, she'd feel the ghost pressure of handcuffs on her wrists. During lunch meetings with colleagues, she'd remember the children's crying faces pressed against school bus windows. The trauma was cellular, neurological, resistant to rational dismissal. She reached out to the school district, obtained contact information for the families of the children who'd witnessed her detention. Conversations were difficult, parents struggling to articulate their children's nightmares, their new fear of police, their questions about why the nice lady in the car had been hurt by the men with badges. Deborah offered support, therapy referrals, documentation assistance, inclusion in the evidence record if they chose to participate. 7 families agreed. Their children's statements, recorded by child psychologists using trauma-informed protocols, became exhibits 23 through 29. The accounts were devastating. One 6-year-old described not wanting to go to school anymore because the bus route passed the spot where they took the lady away. Another 8-year-old had started hiding when police cars appeared in her neighborhood. The case expanded beyond Deborah's personal vindication. It became a coalition. Julian brought in a young paralegal named Tasha Williams, a recent law school graduate from a similar background to Deborah's, who'd chosen civil rights work over corporate opportunities. Tasha's research unearthed precedents, located expert witnesses, built the evidentiary foundation with meticulous care. Community activists joined the effort. Local organizers who'd been tracking ICE enforcement patterns held rallies outside the federal courthouse demanding transparency. Their data complemented the official discovery community-source documentation of stops, detentions, and releases that showed the racial bias in stark numerical relief. The defense filed motions to suppress the smartwatch recording, arguing illegal surveillance of federal agents. Julian's response brief dismantled the argument across 47 pages. Georgia was a one-party consent state. The defense filed motions to exclude the retaliation evidence, claiming insufficient causal connection between the prior testimony and the highway stop. Julian's opposition brief included email metadata showing Kemp had accessed Deborah's judicial profile in the courthouse database 1 week before the detention, suggesting premeditation. The motions were denied. Trial was set for 8 months out. During those months, Deborah balanced her judicial duties with case preparation. She presided over criminal proceedings while preparing to be plaintiff in a federal civil rights case. She issued rulings while reviewing expert witness reports. She maintained professional composure while her personal trauma was cataloged in legal briefs and psychological evaluations. The final settlement offer came 6 weeks before trial. $1.2 million, full confidentiality, sealed record. The contractors would walk away, the bounty system would continue. The institutional corruption would remain hidden. Deborah's rejection took no time at all. She wanted the trial, wanted the public record, wanted the precedent that would make this harder to repeat, wanted accountability that couldn't be bought or buried. Julian prepared the trial notebooks with Tasha's assistance. Witness lists finalized, exhibits organized, expert testimony rehearsed. The case they'd built was comprehensive, methodical, anchored in evidence so extensive that refutation would require either admission or perjury. Deborah sat in her chambers one evening, reviewing the final trial brief. Through her window, Atlanta's lights spread across the darkening city. Somewhere out there, agents were still stopping cars, still targeting professionals, still collecting bounties. But in 3 weeks, a courtroom would hear the truth. The federal courthouse in Atlanta filled before dawn. Spectators lined up outside courtroom 6B, journalists checking credentials, activists wearing shirts printed with the now famous image of Deborah in handcuffs on the highway shoulder. The trial had become larger than one woman's detention. Deborah entered through the judge's entrance, a professional courtesy extended by her colleague who would preside. Judge William Thornton, 28 years on the bench, known for strict procedural adherence and zero tolerance for theatrical arguments. His courtroom demanded precision. She took her seat at the plaintiff's table beside Julian. Across the aisle, the defense had assembled a team of 7 attorneys representing the government and the 3 contractor defendants. Their strategy was already clear from pretrial motions: qualified immunity for the agents, routine procedures executed in good faith, no institutional liability for contractor incentive structures. Thornton's gavel struck at 9A. I'm sharp. The trial opened with Deborah's testimony. Julian guided her through the morning of November 7th, 2025. She recounted it with judicial precision. The time, 8:37 a.m. The location, Interstate 75, mile marker 147. The weather, 38 degrees with frost. Her attire, professional office wear. Her destination, the courthouse. Her credentials, presented and dismissed. The handcuffs, applied without legal justification. The children, sobbing behind bus windows. Her voice remained steady throughout, no tears, no theatrical emotion, just methodical recitation of facts. But the bystander videos played on courtroom monitors told the emotional story she wouldn't. 17 angles synchronized into a timeline that showed exactly what had happened. Deborah's calm request for verification, Kemp's dismissive responses, the tightening of handcuffs, the children's visible distress. The body camera footage from the agents themselves proved even more damaging. Kemp's camera had captured his own approach, his failure to meaningfully examine Deborah's judicial credentials, his immediate escalation to detention. The footage contradicted every element of the defense's routine procedures argument. Then came the smartwatch recording. The courtroom went silent as Kemp's voice filled the space. That's 3 this week. Quota's looking good. $2,200 per head if they end up at the facility. Contractors love high-traffic corridors. Deborah watched the defense table. 3 attorneys leaned together, whispering urgently. The contractor representative sat motionless, faces carefully neutral. The cross-examination attempted to undermine her credibility. Had she antagonized the agents? Had she refused lawful commands? Had she created the confrontation? Deborah answered each question with the same controlled precision. She had complied with every lawful order. She had identified herself accurately. She had exercised her constitutional rights without aggression or resistance. The defense called their own witnesses. ICE supervisors testified about proper detention protocols. The contractor's representatives denied any bounty system, characterizing the payment structures as standard per diem rates for facility usage. Agent Kemp himself took the stand, describing the stop as routine compliance verification with no racial component. Julian's cross-examination was surgical. He walked Kemp through the prior court case, establishing the timeline. 3 years from Deborah's credibility ruling to the highway detention. He introduced email evidence showing Kemp had accessed Deborah's judicial profile. He played the body camera footage showing Kemp's cursory examination of her credentials. Then came the moment that fractured the defense. Julian introduced the internal contractor documents obtained through discovery, payment schedules showing per detainee rates escalating in minority-heavy zones, performance bonuses tied to monthly detention numbers, email chains discussing optimal targeting corridors that mapped precisely to black professional commute routes. Judge Thornton ordered an immediate recess. When court reconvened, he announced preliminary findings. Sufficient evidence of systemic bias to warrant federal investigation into contractor practices. The trial would continue, but the implications now extended beyond this courtroom. Expert witnesses testified over 3 days. Constitutional law professors explained the Fourth Amendment violations in academic detail. Statistical analysts presented data showing detention patterns concentrated in majority black areas at rates that defied random distribution. The probability calculations were devastating, less than 0.01% chance that the targeting patterns were coincidental. Child psychologists took the stand to discuss the trauma inflicted on the school bus witnesses. Video statements from the children played on monitors. A 7-year-old girl describing nightmares about bad men taking people. A 9-year-old boy explaining why he no longer trusted police officers. Their parents testified about behavioral changes, therapy needs, the innocence stolen by witnessing state violence. The defense offered their closing argument around qualified immunity and good faith execution of enforcement duties, but the evidence had already rendered that narrative implausible. The smartwatch recording alone demolished claims of good faith. The contractor documents eliminated any defense of routine procedure. Julian's closing argument was 23 minutes. He walked the jury through each element of each charge, methodically connecting evidence to legal standards. Unlawful detention, proven by body camera footage showing dismissal of valid credentials. Racial profiling, proven by statistical analysis and targeting patterns. Emotional distress, proven by medical records, therapy documentation, and witness testimony. Retaliation, proven by timeline evidence and database access logs. The jury deliberated for 4 hours. When they returned, the verdict was unanimous on all counts. Guilty. Unlawful detention. Guilty. Racial profiling. Guilty. Intentional infliction of emotional distress. Guilty. Violation of Fourth Amendment rights. Guilty. Retaliatory conduct by federal agents. The damages phase took another 2 days. Testimony about professional harm, emotional trauma, medical expenses, the cost of litigation itself. The jury heard about Deborah's sleepless nights, her flashbacks during court proceedings, her ongoing therapy. They awarded $9.7 million, compensatory damages for the direct harm, punitive damages designed to deter future violations. The courtroom erupted in restrained applause before Thornton's gavel restored order. But the verdict was only the beginning. Judge Thornton ordered immediate federal investigations into all 3 contractor defendants. The Department of Justice opened inquiries into ICE's incentive structures. Agent Kemp, Vickers, and Doyle faced administrative demotions and permanent reassignment away from field enforcement. The bounty program that had operated in shadows for 4 years collapsed under public scrutiny within 6 weeks. Deborah channeled the award into establishing the Hatchet Civil Rights Clinic, a nonprofit legal organization with offices in Atlanta, Savannah, and Macon. The clinics offered free representation to profiling victims, educational programs on constitutional rights, and trauma support services. The 7 families of the school bus children received full scholarships to the clinic's therapy programs, plus college savings accounts funded through the settlement. Within 2 years, the clinics had handled 347 cases. 32 resulted in significant verdicts or settlements. The precedent from Deborah's case, Hatchet versus Process, United States Immigration and Customs Enforcement et al. Was cited in 89 subsequent civil rights lawsuits nationwide. Policy reforms followed. Federal legislation curbing profit incentives in immigration detention passed with bipartisan support. Contractor oversight mechanisms were strengthened. Mandatory body camera reviews became standard for all ICE traffic stops. Training protocols on racial bias were overhauled. 5 years after the highway detention, Deborah stood in the new clinic building in Atlanta's historic West End. She was mentoring Tasha Williams, now a senior attorney at the clinic, preparing for a case against a municipal police department. Around them, young lawyers from marginalized communities worked on cases involving unlawful searches, discriminatory enforcement, retaliation against public employees. Through the clinic windows, the city stretched toward evening. Deborah thought about the school bus children, now teenagers, some of them planning legal careers of their own. She thought about the 17 bystanders who'd recorded that November morning, their videos becoming evidence in dozens of subsequent cases. She thought about the quiet fury that had sustained her through rejection after rejection of settlement offers. The highway detention had cost her an hour in handcuffs, professional humiliation, ongoing trauma. But the verdict had cost the system $9.7 million, exposed institutional corruption, dismantled a bounty program, and created infrastructure to prevent repetition. In her chambers overlooking Atlanta, back to her regular judicial duties, Deborah kept one photograph, not from the trial, not from the victory. A photograph from the clinic's opening day, showing the families of the school bus children cutting the ribbon alongside her. Their children's faces no longer showed fear, they showed possibility. The underdog journey from roadside humiliation to systemic reform had proven something fundamental. Hidden strengths, when catalyzed by injustice, could dismantle corruption. Quiet power, when exercised with methodical precision, could transform institutional violence into protective infrastructure. The legacy wasn't just the precedent or the clinics or the policy reforms. It was the message embedded in every case that followed: underestimate dignity at your own expense. Dismiss credentials based on race at institutional peril. Target the powerless. Discover they were never powerless at all. Deborah returned to her docket, preparing for the next day's cases. Outside her window, the city moved through its evening routines. But the systems that had detained her on that November morning were forever altered by her refusal to accept silence as the price of resolution. Justice, it turned out, was both method and endurance. And some traffic stops, when they targeted the wrong person, became the most expensive lessons in civil rights that a nation could learn.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.
Upholding justice is a vital pursuit, and understanding acts as your armor. Thank you for joining us and demanding transparency.